See, I'm going fast now. I'm attorney William Moore, and this is Florida Law on Prostitution. In Florida, the participation in or of prostitution is considered illegal, obviously. Prostitution and solicitation mean the same thing under Florida criminal laws. The state has laid down many charges for various acts that can be said to be related to the act of prostitution. The state has also put a ban on meetings and the setting of appointments relating to the sale of sex. Convincing and persuading another person to take part in the sale of sexual favors is also prohibited. Moving on, it's also a crime in Florida to build a structure for the purposes of offering the service of sex trade. Pandering, or more commonly known as pimping, involves an individual convincing another person to undertake an act of prostitution. What is it? According to the Bureau of Justice Statistics, over 5,000 people were arrested in Florida back in 2010. Florida laws on prostitution are defined as this: the hiring of a person for an act of giving or receiving sexual activity, but this excludes sexual activity between spouses. The state includes various kinds of activities under the definition of sexual act. A sexual act or sexual activity means oral, anal, vaginal penetration by or union with the sexual organ of another, anal or vaginal penetration of another by another object, or the handling or fondling of a sexual organ of another for the purpose of masturbation. However, the term does not include acts done for bona fide medical purposes. Okay, let's talk more about Florida criminal law with regard to the sex crime. The first wrongdoing is considered a second-degree misdemeanor and can lead up to 60 days in a detention facility or a jail. It can also include a fine of $500. Both of these penalties can be imposed. If a defendant has involved him or herself in the act of prostitution for a second time, then the crime is kicked up to a first-degree misdemeanor. It comes with a maximum sentence of 1 year in jail and a fine of up to $1,000. Both of these penalties can be imposed. The third act of prostitution gets a defendant into the felony range, can carry a maximum of 5 years in prison, and a fine of up to $5,000. Can also be considered a second-degree felony if the person procured for prostitution is below 18 years of age. This can lead to a maximum sentence of 15 years in prison and a fine of up to $10,000, or both of these penalties. The Broward County prosecutor can prove that an accused was involved in the crime of the sale of sex by presenting various kinds of evidence to the court. Remember, Broward County Sheriff's officers, Fort Lauderdale police officers, these individuals are not prohibited from testifying as individuals offended by a party. You see this often in sting operations. Let's talk about defenses. A defense attorney undertaking the representation of an individual charged with the sale of sex can undertake several tactical pretrial defense postures. These can be raised in all kinds of situations to protect the accused. The attorney in these situations, handling these cases, is most commonly going to attempt to establish that sexual activity carried out by their client was on a consensual basis and what was not a sale or act of paid sexual favors. Remember, if an individual engaged in a sexual act but was not technically hired or given money for that act, there no charge of prostitution or conviction should lie. This does not apply in situations where a victim or individual sought to perform sexual acts is under the age of 18. My name is William Moore. I'm a criminal defense attorney with W.R. Moore, Dorenzo & Wyke. Thank you.